So you get a new job. You sign the contract, right? You scan through the salary, the hours, the holidays, and you figure, yep, I know the rules. But what if I told you that document is only half the story? You see this official looking paper and you just assume it covers everything, the whole relationship with your employer. But does it really capture it all? The expectations, the handshakes, the things that just go unsaid? The answer, almost always, is a big no. And if you're feeling skeptical, you should be, because some of the most critical, most legally binding rules of your job are completely invisible. They aren't written down anywhere, but they have very real power. So it's time we pulled back the curtain. Okay, first things first. Let's start with what we all know, the contract you actually held in your hand and signed. In legal speak, these are the express terms, the stuff that's spelled out in black and white. By law, your employer has to give you a written statement with these basics. You know the drill. Who's who, when you start, how much you're paid. This is the bedrock of the agreement. But really, this is just the starting point. The really interesting bits are in the details the contract seems to gloss over. And this is where it gets fun. What about those terms that seem solid but have a little wiggle room? Like a bonus that's described as discretionary. Does that just mean your boss can wake up one morning and decide not to pay it, even if you've absolutely crushed it all year? Well, not quite. The courts have made it really clear that even discretion has limits. There was this huge case where a top investment banker was denied a bonus, and the court decided that an employer's discretion has to be used rationally, in good faith. It can't just be random or unfair. So here's the key takeaway for you. Discretionary does not mean arbitrary. It should be tied to your performance, not your manager's mood. Okay, so let's push this a bit further. What happens when a massive promise is made, but it's not in writing? Can a casual chat actually become a legally binding contract? Get this, it's a wild story. The owner of Sports Direct, Mike Ashley, was in a pub with an employee and supposedly promised him a £15 million bonus if he could double the company's share price. And he did it. The share price doubled. But a court later said, sorry, a promise made in a pub, that doesn't really count as a serious, legally binding offer. The lesson here? Proving a verbal agreement is a major uphill battle. So all of this leads to the big question, right? If pub promises don't count, and even the written stuff can be tricky, what governs all the things that are never even mentioned? What rules are filling in those huge gaps that exist in every single employment contract? This is where we find the invisible rule book. And it's governed by something called implied terms. These are the powerful, unwritten rules that courts automatically read into your contract to make sure everything is fair and actually works. Put simply, implied terms are the rules that you never wrote down, never even talked about, but are automatically part of your contract because of the law. And make no mistake, they are just as legally binding as the salary figure you signed on for. Now, these terms don't just appear out of thin air. They come from some pretty solid legal sources. Some are baked into laws passed by Parliament, like anti-discrimination rules. Others come from custom and practice. Think about that Christmas bonus that's been paid out every single year for 20 years. At some point, it stops being a gift and starts being a right. Some terms are just obvious, the goes-without-saying stuff needed for business to even function, and a whole lot of them are built on decades of court decisions that have shaped what a fair job looks like. Okay, so these unwritten rules exist, but what do they actually do for you, the employee? Well, they create a whole bunch of powerful duties that your employer owes you, whether they ever said so out loud or not. At its core, there are three really big ones. First, the duty to pay you. Second, a fundamental duty to take reasonable care of your health and safety, and yup, that includes mental health and stress. And third, maybe the most important one of all, is the duty of mutual trust and confidence. This last one, the duty of mutual trust and confidence, this is a huge deal. It's considered the absolute cornerstone of the entire employment relationship. It basically means your employer can't act in a way that's likely to destroy or seriously damage the trust between you. It's the invisible glue holding it all together. So what does a breach of this trust actually look like in the real world? Well, it could be demanding you relocate across the country without any reasonable notice. It could be the company just being dishonest. Maybe it's a total lack of communication about major changes that affect you, or them deliberately ignoring your formal complaints. It could even be creating a work environment with so much stress that it becomes unsafe. All of these have been seen by courts as a breach of this fundamental, unwritten rule. So we've got these two sets of rules, the written and the unwritten. But what happens when they're actually broken? This isn't just theory. The consequences are very, very real for both sides. It's a two-way street. If an employee breaks the contract, that can be grounds for dismissal. But if the employer is the one who commits a serious breach, like breaking that core bond of trust, the employee can sue. They might even be able to resign and claim constructive dismissal, which basically means arguing, you didn't fire me, but your actions made it totally impossible for me to stay. So, the crucial point here is this. Your employment contract is so much more than that document you signed on day one. It is not a static set of instructions. Instead, you have to think of it as a living, dynamic relationship. It's governed by a whole complex web of rules, some written down in black and white, and many, many more operating silently just beneath the surface to keep things fair and protect both sides. And all of this leaves us with a critical question for the future. As things like AI, remote work, and constant workplace monitoring become the new normal, what new unwritten rules are we going to need to protect fairness? What will trust and confidence even mean in the workplace of tomorrow? That's a question we're all going to have a hand in answering.